Well, it's maybe part of that is the vigilance for application losses. Can it be taken up next week? Let's see, any day on Thursday. This part had hearing and concluded for the vigilance side.
Who are you hearing from?
Maharana.
One is change the side. Now you have to give the copies to whoever is appearing.
And next Thursday, Lord's.
Okay, Thursday you give the copy.
We'll serve it today.
Yes, yes. Yes.
Lordship permits, sir.
Yes, sir.
Lordship permits item number 8. 8 court. The Lordship was the student.
Yes, yes.
This case has been fixed to be taken over 3 notes. That's
That
my
3 frame business is very difficult.
also let it not today, my lord. So this matter taken up with another another case when I'm giving the case number serial MC of 390.
Note it down and adjourn it up or something.
Along with this case, my lord, the same
Along with that, huh?
CRL MC number 396 of 2020.
Short.
No, he'll give it. He'll adjust and give. Don't hurry up so that he'll give a date, will not be taken up.
Pardon me, Lordship. The Lordship on CRLMC matter. Lordship challenging the order.
Give memos.
Yes, sir.
Give memos.
No one's time.
All memos will give.
No one transferring matter. What was the order of another district court? Next to the case in transfer for on software. No, I am problem.
Transfer matters are not in this assignment.
No, against the order of district court.
What have you filed?
CRL.
Give the memo and see.
No, urgent matter software closed stage.
So then what will happen? Evidence is taken, even then it can be transferred. What will we do? If that court record the evidence, come to a conclusion, it can be transferred. Along with the evidence, it can come. What is the big urgency about it?
No, urgency.
What urgency?
I am improved in this case.
That's right. What is the urgency? Transfer is not so urgent. We'll see.
50% the court is closed.
Yes. Next. 11. Okay. Mr. Chand and counsel for the petitioner submits that there is a bereavement in the family of one of his clients. Hence he seeks an adjournment. Release the matter. Making it correct.
This is a criminal appeal matter specifically adjourned to today, my lord. Mr. Lieutenant Counsel, Mr. Boss.
When the matters are ready for hearing, you ask for adjournment.
No, my lord.
And I wanted to impose a cost of 5,000 rupees. Yesterday somehow adjourning. Now you want listing.
My lord, specifically adjourned to today. Lieutenant Senior Counsel.
But get ready that matter. I have written your name.
Yes, ma'am.
I'll not leave you. You have to argue that matter.
Yes, ma'am.
Otherwise, 5,000 rupees I'll impose cost. Get ready with this matter.
My lord, Monday, my lord, this matter.
We'll see you Monday.
My lord,
Yes.
my learned friend has taken time in item 8.
Yes, sir.
My lord, it will be taken up someday or 18th or 19th. 19th.
I'll just see and
Because
preferably 18, 19. Just see how can you adjust.
My lord, senior is there, my lord. I am asking time in item number 48. I am for the informant.
14.
Opposite party. 48.
48.
Correct.
Ordered. Okay.
Any day except 22, my lord.
He will adjust it. 22 only.
Entry order to control.
Entry mode to control. Yes. Yes.
Item number 3 notes.
3.
I have taken the consent of the petition counsel in fact Mr. Maharana is not available in court today notes. It will come Monday notes.
Interim order.
Entry mode. Then there is entry order. Why Monday? Let it be after 1 week thereafter. Okay. Yes.
No, please, Ratsman, item of 4 matter, compromise matter, and it's matter taken up next to matter, both the parties will be formed.
Why? She compromise letter, you should bring them. Why unnecessary burdening the court like this? If it's compromise, why don't you bring online also? You can bring at 2 o'clock.
They will come, not come this matter.
They are notice. We wait for them. They are accused, they have to be, you file a compromise petition to bring them. Unnecessary, these matters are occupying the list. List it up. Yes.
Item 4.
What are the offense, by the way?
307 and other offenses are there, my lord.
Yes.
Item 1.
Mudra. Yes.
Raise all these issues.
Yes. Liberty to raise all this. Yes. Yes. Item 2.
May I please?
The second bail application of the present person at the stage of investigation, you must be directed to move up. Yes, my lord.
Yes. What happened? What was the order? No, it is not disposed of. It's pending. When is the date?
28th of October.
28th. Oh, up to the other date. There is some mistake taking place. 28th October it was supposed to be meted. It somehow there was some problem. Anyway, use it and do this order. Yes.
Sorted.
Which one?
Item 2.
Item 2 I am giving it a due so that we'll see. Yes.
Okay.
Item 5.
What had happened is this matter item 2 was adjourned to 28th of October. And there is problem in my back office. They have written something, I don't know, not related to this case. And this matter could not be listed. So therefore, yes.
Item 5.
Quite.
It's application, the question of the criminal society. And dispute between the one, both are advocates. And the allegation was made by the junior against the senior. That he has assaulted it. And the main allegation is against
Junior is assaulted senior.
the junior, senior, not the junior.
Then it is permissible. Senior can be junior, but not junior. Junior is not possible.
Well, the main allegation is against the wife of the petitioner, madam.
What are the offences, by the way?
Minor offense.
193.
See, issue notice. Issue notice. And shall I send it to mediation? State I will send mediation. Both of you are lawyer. I'll stay it and
Mainly allegation is 5 check more urine.
I'll send it to mediation. I'll send it to mediation, stay the proceeding. Okay.
Mediation proceeding to state again.
Yes, state. That's right. Petitioner is agreed by the in the present petition is seeking passing up for the order dated 17/1/2015 passed by SDJM Chhatrapur, Punjab in ICC case number 22/2015, whereby the cognizance over is that order. Who is that order? Whereby the cognizance of offences punishable under section what are the provisions section 223, 294, 506 IPC has been taken. Mrs. Mahapatra, the counsel for the petitioner submits that the petitioner and opposite party number 2 both are practicing lawyers, and there is a Barampur, and there is a possibility of settlement between the parties. Issue notice to opposite party number 2, reasonable so and so, and since both the petitioner and opposite party number 2 are practicing law, I will mediation district mediation center Barampur. Why should they come?
I would appoint.
High Court. High Court mediation is directed so also, and the proceeding pending before which court? Proceeding in SDGM Chhatrapur in ICC case number 345 of 2014.
Transfer is 22 of 2015.
Renumbered as 22?
160 case number 22 of 2015.
22 of 15 is state. And in mediation report, please the matter. Yes.
Item 6.
Yes.
My learned friend had taken time, my lord, to see my lord, here is a case where an application was filed before the learned sessions judge to pass an order to commit all the complaint cases pertaining to the present case to his court so that there should not be multiplicity of trials for the same case.
Yes.
And accordingly, an application was filed. My lord, may see the rejection.
Notice was not issued in this
My
case.
lord,
Notice was not issued.
so Tilpalat state of Orissa is the party.
For a completed losses, may kindly see 210.
Huh?
210.
210.
Resurrect.
210. Yes.
Procedure to be.
Hmm.
Procedure to be followed when there is a complaint case and police investigation in respect of the same offense. The language is
Same offense.
Then your losses may kindly see the FAir at page 49.
My lord.
Yes.
Page 49.
14. Yes.
The offense is my lord 420.
Yes. 448.
468, 469, 472, 475, 487, 270,
Yes.
274, 34,
Yes, I got it.
and 86, 87 of
Trade and Worker Act
Articles Act.
and 63 Copyright Act.
63 copyright.
Yes.
Then your losses may kindly see, my learned senior has filed the 1cc cases manner. That is in the record man.
Perhaps, my lord, without calling for the records, well, let me clarify. Perhaps without calling for the records, well, current friend has submitted this because in the case, well, I have not.
Now, what is the stage of investigation?
Well, what stage investigation has been completed, my lord.
Where is the charge sheet?
I've got the charge sheet with me, my lord. Final thought.
You get see, you have to see the charge sheet. What
What I want to say, my lord, you should verify. In the charge sheet, number of seizure lists are there. What they have done, for each seizure list, a separate complaint. 10 complaints have been filed. And wrong
I
inspector.
am also bringing that your losses.
Huh.
And your losses may kindly see in the complaint petition, what is the offense?
Yes.
That is page
20.
21, which you filed yesterday.
20, page 20.
Yesterday.
Yes.
And it out in 1 week.
20.
To CC.
CC case number.
Yes.
There your losses may kindly see the offenses.
Hmm.
That is rule and section converted, then penal section. 27B to 27C, 28 of drugs and cosmetics.
Hmm.
The offenses are not equivalent.
For example, my lord,
Any sections may be different. What are the allegations?
without perusal of the CD, well, let's say one seizure list. Of the charge sheet, man.
Mm-hmm.
Seizure of articles like one.
You get the CD, let us understand. Get the CD. Let us.
Proper submission.
Yes.
It's not expected from your office.
Move 210 to I'm placing.
Now, see, all documents are not there. Charge sheet is not there.
I'm giving it, I'm filing the copy of the charge sheet to my, giving a copy to him.
Take it and
I can draw.
if for the self-same allegation 10 cases are there, then we can see
I was drawing my lords
That
at
is special specific.
I was drawing.
Unless unless they are the inspector or my lord, any officer in the rank of director, he cannot, the drugs and cosmetics act cannot be instituted. And here is the.
My lord,
Yes.
My lord,
you get the CD.
my lord, one only for prime basis, my lord. My lord, this seizure list. One seizure list.
I understand for every seizure there is a corresponding case.
My lord. And drug inspector definitely will be the complainant.
You will appear for drug inspector also?
Yes, sir. Government servants, my lord.
Yes. You have implicated so many people. Who are they? Item 6, na?
Item 6.
1 minute. 6 minutes.
Not so many people.
9. Sorry. Okay.
I have referred the discussion.
Yes. For drug inspector also you will appear. Okay. Seek instruction, let us see what can be done. Yes. Next.
That order, entry model.
Entry mode. Same entry management. CD of the case is called for. Mr. Jana will file a response to the petition the interim arrangement made in the earlier yes,
2 weeks after.
2 weeks after 2 weeks, yes.
Item 7.
Mayor, please vote.
Challenging the initiation of the proceeding against the present petitioner under annexure 2. Running page 14, the petitioner has filed this petition.
Running page?
Representative statement.
Good.
Page
But-
14.
Rohan, question?
Yes.
The father of the petitioner was the recorded tenant in respect of the land under Khata number 3 of Khatam Mauza. And the land is a cultivable land. The petitioner has constructed a boundary wall to protect the land from the cattle along with others. Over the right to property, he has constructed a wall. Some of the villagers have made allegation before the learned magistrate, sub-regional magistrate, alleging that due to the construction of the boundary wall over the property, the water could not be drained properly. For that reason, they have initiated the proceeding. And now the sub-collector under Annexure 2 issued the notice to the petitioner for appearance and file the show cause. Admittedly, I am the owner of the property.
DNS chapter 133.
My lord. But
And this is just show cause notice only issue. Let him give everything before the.
So cause notice only.
if I was constructed the boundary, I will tell that to the concerned authority, sub-regional magistrate.
My lord, petitioner is agreed by the.
Your lordship, may kindly see, I therefore hereby.
I accept whatever you say. My lord, but you don't tell me till right person.
In fact,
You are correct, absolutely correct.
my lord, but
I see, it is only.
protect to construct a boundary wall over my.
I understand, whatever you say, I agree with that, right? Petitioner is seeking passing up for the proceeding in which he said against him under section 152 of BNSS, BNSS. In CRLMC number 2223 of 2024 of 2024. The case is at the nascent stage. Only notice has been issued to the petitioner by the sub-divisional magistrate on 30th October 2024. Therefore, at this stage, I am not inclined to interfere in the matter. However, liberty is granted to the petitioner to reply to the notice issued by the sub-divisional magistrate on 30th October 2024, raising all the points as has been taken in the present petition. If such,
May I pray one thing? This October,
since the time for filing written statement has already expired, the petitioner, counsel for the petitioner seeks extension of the same. Let the petitioner file the response to the notice issued by the sub-divisional magistrate on or before. You tell me on or before 30th of August. No, 30th of no.
and then
What happened?
who may pass any order.
No. Yes.
But till then,
No. I am not entertaining the petition. I am giving this. Yes.
Item 9.
Indian business is very dangerous.
Nine, my lord. I will pardon my lord. Last time my lord has had at length, my lord. The whole question is whether without sanction, charge sheet can be filed or not. Last time I have come with 7 to 8 decisions. My learned senior has filed a decision against me. Yesterday, due to my head reeling, I could not get. I pray after 26 any day. I want one thing more, my lord. If I file an urgent petition, I will not take further urgent shorter.
You are asking for adjournment here also, there also. What is this?
After 26 any day,
I'll put it on 19th. I don't think you have a case on merits.
At the, without charge sheet, at the time of filing charge sheet, I was in service.
So they are covered by the judgment, therefore you short time to study that judgment on that day.
73 should.
And you actually, you read it rightly, the judgment, after reading the judgment, the defense started.
No, I have got points in my favor, 78 cases.
Then I started.
But still, but service also, short argument help kale, that will be adjourned.
No, I put it next week anytime, next week.
Next week, 21 वर्ष छाड़ के निकल.
एक कुछ week छाड़िए तो ठीक है, okay.
19 or 20 adjourned.
Yes. Yes, tell.
Yes, it's a Belgium matter, my lord. Yes, NBW has been issued on 18th July. 18th July.
18th July.
My lord.
Yes. Bill.
Bell.
There are no appendix B rule.
John Bean 500. 30. Yes.
Item 12. Belgium matter.
Belgium Matrimonial imbue issued on 5/9/2024.
5/9/24.
Petitioner was on bail, but
Date you don't.
date
5/9.
Bail order का देख. Bail order का देना भी लेकिन अनविटेबल.
Item 13 millets, Belgium Metro millets. NBW is 27/3/2018, page 10 millets.
Yes.
And petitioner was on bail by order at 1/11/2008. That will be seen from page 18 of my additional document flag here, your lordship.
Okay. You pay 1,000. 1,000.
14.
My lord, NBW issue 37/2024, my lord. Petitioner was bail on 3/8/2005, my lord.
That's 500. How many appear? 500, yes.
Item 15.
Now, please, your similar Belgium matter. NBW audited 10/5/2024, running at 14 minutes. Real matter 23/2010 minutes.
NBW 22.
NBW 10/2022 रेच.
Right, okay.
23/2002 को जेल चला.
500.
Matter obliged.
16.
16 manner NBW is 26 April 2024 and 41 in notice has been served 21.
While investigation was going on, notice under section 41, he was served upon the petitioner. However, the charge sheet was filed against the petitioner by the police, showing him in absconder, and accordingly, NBW was issued by the court below
26
on
26
26
April
2024. Okay. 500.
Obliged.
17.
No, please, my lord. My lord, on 19/9/2024, NBW was issued where petitioner was earlier on bail, IC/22.
NBW issued on
19/9/2024.
24. Okay. 500.
Oblate.
18.
earlier he was on bail on 17/9/24. Pending of charge, he could not appear. NBW has been issued on 17/9/24.
Okay.
Page 7.
Okay. 500.
Obliged.
19.
issued 12/8/24. They were released on bail by 22/8/2019.
22/8/2019. And
NBW 12/8/24.
12/8/24. Okay. How many of you were there? 500. At 500 each.
Schedule ladies schedule premium.
Okay. 500. Yes. 500 total.
NBW issued on 20/5/2024.
20.
16/8/2024.
16?
16/8.
August
16/8/2024. Religion bail on 13/9/2008.
208, huh? 500.
21.
Where please was. But in this case, my lord, I have challenged the paying for passing of the interchangeable procedure as well as the NBW issued against the petitioner. On the ground, my lord, I have been implicated under section 29 of the NDPS Act. My lord.
Hmm.
Il also may kindly turn to case 24.
24.
24.
Yes.
But this, in the middle portion, my lord, just last, my lord.
Yes.
6 lines above.
Yes.
Only one word has been written. He purchased ganja at low cost, rupees 1,000 approximate, from different remote villages of Sunki area and other places of Uttarakhand and Malkanagi district. Kartika Lama and Sankar Lama of Bogopondi, Jaipur is the potential partner. This is one word. This exactly, except this word, there is no other evidence are available. Most particular manner, Lordship can be shown to, where the important thing is that in page 31, similar allegations, similar set of evidence in 8 cases.
Yes.
Page 31 is systematic.
31.
31.
Yes.
On the application of my wife, the superintendent of police investigated the matter. 8 cases, similar allegations, similar set of evidence. 8 cases have been exonerated against the petitioner. You also kindly see the preliminary portion. After review, the 33 clause was last, after it is after 8 clause 8 after.
Yes.
33 clause.
After we review.
Yes. After reviewing all the above NDPS case, it is seen that there is no direct evidence against Narasimha Bahadur alias Kartika Lama, this petitioner. Regarding supply of contraband ganja for transporting to different areas of the state and beyond the state, except the confessional statement of the arrested accused person, the IAO in all above cases have not succeeded to prove the involvement of Narasimha Bahadur alias Kartika Lama by collecting other corroborative or sufficient prima facie evidence against him. However, in anticipation of arrest by the police, Narasimha Bahadur alias Kartika Lama is actually from Jaipur and he has not been arrested in any above mentioned case. However, after recent judgment of Honorable Supreme Court that confessional statement of co-accused cannot by itself be taken as a substantive piece of evidence against the other accused persons, other co-accused persons. Under
What is this document you are reading?
but this is the investigation carried by the SP on the application of my wife that I am innocent. I don't have any role. So far the cases are concerned which are police has implicated me in all 8 cases. 8 cases,
Total how many cases?
total 10 cases. 8 cases are exonerated on the same set of evidence and a specific person. Under the above circumstances, it may be mentioned here that without collecting any other authenticated and concrete evidence, it is not proper to submit charges against the abstaining accused, Narasimha Bahadur alias Kartika Lama. This is the final conclusion so far.
And what the charge sheet is not filed in the
8 cases are categorically same set of evidence. Why this present case will be exactly the same set of evidence?
Did you follow?
There is no justice, sir. Only
See, 10 cases are foisted against this man.
Yes.
And only charge is he is what is that lying sentence? What is
Somebody stated that he was supplying the ganja.
somebody stated that he was supplying. Somebody means one of the co-accused.
Right.
Yes. Confessional statement, he says that he is supplying ganja. This is the only 10 cases were filed. Then out of scared, he absconded. And the wife writes a letter to the superintendent of police. Superintendent police find out that 8 cases are false because there is nothing. And exactly the same 8 cases where he has been exonerated by the superintendent of police and directed not to file charge sheet. Same allegation in this case also.
That's what
Not been listed. Also, my lord,
Get the CD.
because if that 2 cases SPS.
Maybe in the 2 cases, maybe some evidence may be there. I don't know. Maybe there you might have collected. You never know. So in this case, you get the CD. If the same set of evidence is there, there is nothing except confessional statement. We can be charged. Only you say this one line. One line.
Nothing else. No,
If you have anything,
given the address,
let him get the CD.
yes, sir. Because the NBW is issued against me.
I'll say the only.
Yes, sir.
Take the NBW and get the CD. The issue is Mr. Maharaja, learned counsel for the petitioner, submits that 10 cases were falsely foisted against the present petitioner. On the only allegation that he is, what is that allegation? Wherever he is that,
Applying the ganja and transporting the ganja.
no, where is that?
Last case, just last case 24 case.
Where is that?
Plus last.
Yes.
Just 6 lines above. On 24 case, 6 lines above. 6
On
lines.
the allegation that the petitioner is purchased the ganja at lower cost from the remote villages. Villages and supply the same. Supply the same to the potential drug dealers. Drug dealers. The petitioner had been absconding. The wife of the petitioner wrote a complaint to the superintendent of police.
Yes.
Inter alia stating that the petitioner has been falsely implicated in all the 10 cases. In-house inquiry was carried out by the superintendent of police and arrived at a conclusion that 8 cases have been falsely registered against the present petitioner on the basis of only the confessional statements of the co-accused sans any other materials, sans any other material. Mr. Maharaja submits that on the self-same allegation, without there being any evidence except to the co-accused confessional statement, the present case has also been initiated against the petitioner. Since the petitioner was shown to have been absconding, NBW has been issued against the petitioner on 5/4/2023 by the additional session judge, special judge Jaipur in PR case number 39, capital A for 2021. Issue notice, Mrs. Naik accept notice.
Madam.
Madam, accept notice. Written within 3 weeks. 3 weeks. 3 weeks. Call for the CD and the execution of NBW issued by the court below by order dated 5/4/2023 shall remain shall be kept in events till next date of hearing.
Yes. Yes.
I'm not setting it, I'm keeping it events. If material comes, then I'll revive it. Yes.
Then the materials, then that is materials. So you proceed to.
Yes.
You also can you fix up it? Some date.
I'll fix it after 2 weeks. He's get the document.
Yes.
Yes.
22.
Petition of Hon'Ble provided an order dated 19/7/2023 and we don't issue.
You were on bail and give the date.
1/2/2026.
1/2/2020.
1/2/16.
1/2/2016. अच्छा, NBW 19/7/2023. ठीक है? 500. Yes.
23.
May I please your lordship, NBW was issued on 9/10/2024, my lord. My lord, on the date of framing of charge, my lord, the petitioner could not appear, my lord. My lord, I don't have the exact date of bail, my lord. By order dated 12/9/2019 in a bail appeal number 4604 of 2018, the petitioner was directed to surrender and released on bail.
Page 23, the order dated 9 October 2020. That
31. 9th October.
We had 370 petition, which was rejected by the.
It's all right. Yes, go and appear. Let him go and appear.
Yes.
Yes. 500.
It was directed to remain present along with the other way.
He has to go and resort to the revenue. Let him go and appear in court.
Yes. That
all these things are coming because of you. If you execute the NBW, nobody will come here. You are not executing the NBW, therefore these people are coming here. It is your problem. So you have no right to, in true sense, you have no right to oppose. You execute the NBW, nobody will come. Yes.
Grateful.
24.
No, please, very grateful. Fundamentally, as a student, 23/2024 में लग, लेकिन the petitioner were on bail 22/21 में.
Already.
Please, my lord. NBW was issued on 4/24 matter.
Sorry?
NBW was issued on 4/2024.
4/2024.
And he was going to boss to start the these. These are these.
500.
26.
Yesterday matter, I have been arrested on the basis of the statement of the co-accused. Occurrence, my lord.
Custody from?
My lord,
Custody from?
custody from 13/8/2024.
23. Okay.
24.
24.
Yes. And occurrence on 9/7/23. Charge sheet was submitted on 5/1/24. 5/1/24.
Nothing open seized.
And nothing has been seized from my conscious possession. Only on the basis of the co-accused statements, I have been arrested and languishing in the custody.
Yes. What is the recovery by you?
Recovery is 420 kg. Not from me, my lord.
The present prisoner is fled from the spot, your lordship. 2 persons have been cutting by the police and they disclose the name of the present prisoner, lordship. But facts remain there is 13 bricks each. Well, 15 numbers of bricks are there. And the 2 bricks each are loaded.
Tell me any antecedent.
So far present prisoner is concerned.
No antecedent.
So for present prisoner is concerned, shows that no antecedent reports in this for the including order is not very so specific instruction are not.
Arrested in incident same day.
No.
The present prisoner is absconded also. From this court, when arrested in the August 2024, lordship.
After 1 year.
What is the evidence you have shown me that he was in the spot and fled away?
That is the only basis of the confronted with the accused who is controlled by the police, lordship. He disclosed the name of the prisoner, lordship.
That is neither than that.
Yes, that is the lordship. No, but I am not disputing that. This is a basis of-
Have you collected any evidence that anybody has seen or and police officer said that yes, he was running, I saw anything of that sort?
That part, no one has mentioned about the, and only the statement of the
I
court.
understand you, the police troop goes there, 3 people are there. And one of them is running and somebody is seen.
That part.
Then at least you can relate it.
Yes.
If you arrest him after 5 days, 6 days, what is citizen is accused in so and so.
But,
Allegation.
quantity is 30 kg, lordship. Please say the that's for not.
420 kg.
The total 4 and 20 also. This is 30 bags, 14 numbers of bags are there, lordship.
14 accused.
No, 9 accused are there.
9 accused. But the problem is, see, 37 bar doesn't operate because no antecedents.
No antecedent.
But in this present prisoner lordship, specifically instruction not to 3 for the time being, so far my antecedent is concerned. But in full order, there is no mention about the antecedent.
Are you sure that I am not instructed on 19?
Yes, lordship. Suspicion
19. You only tell me antecedents.
Yes, lordship.
Then the 37 bar doesn't operate.
36 bar.
Doesn't operate, so yes.
Okay.
19.
The petitioner is a 20 years old owner of the vehicle minor. He is in custody since 24/5/2023 minor.
23.
Yes, minor.
Yes.
And he has no criminal antecedents minor.
Yes.
And last occasion, your lordship had called for the CD and status of the client.
So far, 27.
27.
Have you got the present prisoner in the state of Bihar? Have you got the police? Yes, lordship.
Yes.
The present prisoner so far belongs to the state of Bihar and is the helper, lordship. Present prisoner is the
Helper of the vehicle minor.
What is the recovery?
helper. And why he was writing
257 kgs, 800 gram minor. And it was seized from 2 persons minor.
But
And he is a helper of the vehicle.
both helper and driver are in possession of the 270 kg also ganja.
Conscious position.
Yes, Your Lordship.
Yes. 250 kg.
57, also.
Antecedents?
So for antecedent part is concerned, I will specific instruction so far present person is concerned. There is no CA, Your Lordship, so far present person is concerned. Niroj Kumar, Your Lordship.
What is the stage of the trial?
My lord, charges had been, as per my instruction, charges sheet was filed on 9/11/2023 and charges have been framed on 27/2/24. My lord.
Call for a report, huh? Call for a report from the court.
My lord, already he is in 1 year and 5 months.
What is the recovery you have seen?
My lord. But it was not seized from his auxiliary position.
You were there in it.
I humbly
You were there in the trial. Let us see the trial position. Otherwise, Ravi Prakash, I'll use Ravi Prakash to enlarge only. Very big thing. Yes. Huh? Get a report from the court. Yes.
28.
Number 28. Your lordship was pleased to pass an order on 30/10/2024. Calling for the fresh status of the
Yes, Your Lordship.
Report hasn't come. Please, the report hasn't come. This verify. Next week.
My lord, on 27/8 also, your lordship was pleased to call for the
Report
status.
hasn't come. Just check it up, huh? Right, okay? And next week, put it next week, yes.
Flag J, it is at flag J, man.
No, it's not there.
It is not there.
Not there. I'll verify next week.
There,
No, J is not there.
flag J.
J9.
It has been received from the.
Yes, he's
Yes.
correct, he's correct.
Yes,
12/11, there is a report.
Yes, madam.
The 12/11.
My lord, in this case, petitioner,
But out of 38 witnesses, 10 witnesses have already examined.
witnesses have been examined and none have supported the prosecution case. Apart from it, my lord, I am in custody from 9/7/2023.
9/7/23.
7/2023.
Do you have the year?
Next, my lord.
Huh?
The annex the deposition.
Yes.
And your lordship may kindly turn to
Your bail application rejected when?
bail application rejected on 2/8/24. Your lordship was pleased to reject it on 2/8/24. Your lordship may kindly, in that case, that
Annex 3, Your Lordship.
your lordship may kindly, firstly, recovery is about 60 kg, 400 grams, insofar as the present petitioner is concerned. Secondly, 60 kg, 400 grams. Your lordship has quoted it, my lord, page 31. Page 31, your lordship may kindly turn to page 31.
420 kg divided by 40 kg. That's good.
Yes, Your Lordship.
But recovery 420 kg.
Yes, I am, your
Yes.
lordship.
So many deposition if
Deposition, my lord, PW3.
have you seen?
Yes, Your Lordship.
Huh?
Yes.
Yes. Any evidence has come on record?
So far, those witness examined, these are the government witness, Your Lordship. So far, material witness is concerned, that part I have no instruction of the last.
Who all are the material witnesses?
Your Lordship, those persons.
Right.
You tell me who are the
Yes,
material.
Your Lordship.
Women, your lordship may kindly turn to page 28.
Yes, I'm there exactly.
Nothing was weighed in my presence and in my weighing machine.
I was not examined by the police. I put my signature on the paper form. With my signature on the body of them. Not a
In 6, we would have just disclosed. In 6, we would have changed. The executive magistrate, cross reference, of the machine.
Yes.
Your Lordship, Durjay Kumar Sahu, who is the material witness, not been examined. Your Lordship. Vijay Kumar Sahu, your lordship, Malik, your lordship. Acting is, your lordship, also IAC on the spot of the occurrence in the presence in that day in the patrolling.
Who is that Sahu?
In the Hon'Ble, your lordship, on the date of the occurrence, in the position, in the present, Vijay Kumar was present in the spot, your lordship. Not been examined, your lordship. It is clearly stated the name of the present person, lordship. In his 161 statement, lordship.
162.
But the seizure witnesses have not supported what to do?
Yes.
But actually, the present petitioner who was during this time of the seizure, and he was present in the spot.
But then PW1 says that nothing is seized in my presence. PW2 says that nothing is seized in my presence. PW3 is the same story.
That
And executive magistrate also said,
What are these exhibit? You know, exhibit P1. Exhibit P1 by 2 exhibit P the ganja which was been seized. What are those exhibits? Whether this nothing is it is regarding weight. He says that it's not weighed in my presence. And the seizure. What is the exhibit mark? Seizure.
but speaking of instruction for the time being, lordship.
You tell me what this seizure is the seizure witnesses, seizure of what? Is it seizure of ganja or seizure of something else?
Yes, that part not.
You tell me what are these exhibits?
Yes, lordship.
If these exhibits are nothing but the seizure of the ganja, then entitled to bail.
Yes, lordship. That.
Because seizure is not proof. Tell me exhibit.
Yes, lordship. I was to
Next week, put it.
hello,
Exhibit, you have to tell me the exhibit. See, PW1 and PW2 says that nothing was seized in my presence.
Yes.
I was not examined by the police. I put my signature on the paper marked on exhibit so and so so and so. What are those exhibits? Whether it is related to the ganja or something else.
seizure of ganja or something else.
If it is related to ganja, you are straight away entitled to bail. You just tell me that. And both the PW1 also says the same thing, PW2 also says the same thing.
And 3 also same.
See, 3 is relatable to ganja because weighing means ganja only.
Yes, yes.
So therefore just coordinate it and tell me.
Your lords,
You have to do it and tell me.
your lords,
Then you are the prosecutor. You have to do it obviously. Next week.
your lords, may put it to 19, not 21. Only 19, 20, your lords.
22. 22nd. 22nd. 22nd.
Oh, bless.
Just ask the local TP to assist you.
These exhibits.
And any other witnesses are examined by now or not? Yes.
No, nobody examined. As far as my instruction is concerned. Lords, may out.
I don't put the line.
Maybe, yeah. There is a case where the hardware my lord. And because of the fact that after charge sheet, I have not approved the court below, my lord directed me to go and I approve the court below. Accordingly, I approve the court below. The entire allegation is based against what the petitioner is concerned, is solely based on the co-accused statement, my lord. 7 except co-accused statement, absolutely nothing is there. And that is my submission.
Yes, also submitting the disclosure statement of the principal accused who is before the Tahsildar is clearly stated, your lordship, the Tahsildar, your lordship, and
What are the offences?
your lordship, another alleged offense, your lordship.
There is a case where it is alleged that the my lord, person who has been killed in the present case, he has taken supari to kill another person at Odisha. And thereafter, my lord, he has somehow materialized it by giving firing shot. The person one G. Mishra, one Gauri Prasad Mishra, he has murdered her.
Also, there are other matters are pending.
Yes, there is another
and that particular, after the killing of that particular person, when he has demanded the further sum, the person who has engaged him to kill that particular Gauri Prasad, they somehow call him to come to a particular place. Where it is alleged that is not coming onto Odisha, that is coming onto the other state, Andhra Pradesh. And there it is alleged that
they have come.
Somebody gave the supari to kill someone.
Yes, exactly, madam.
They killed him.
Madam.
And the supari money was not paid. They went and asked the supari money, he didn't give and received him also.
Madam. So this is comfortable of the allegation. So now my role is there. I have managed so far neither at the time of that killing because that particular person who has been killed, he was. I am concerned with that case. I am accused. Now also accused of this case. So far the FIR is concerned. FIR doesn't mind this.
No, give me the charge sheet. Let us see. These are two gruesome murders across the state. One is Andhra Pradesh, another is you give me the charge sheet. Where is the charge sheet?
I am reading the disclosure.
You file the charge sheet.
It's clearly mentioned.
I will not.
Yes, I will file.
File the charge sheet.
Yes, sir. The disclosure statement recorded before the executive magistrate also.
Apart from disclosure, that's what he is arguing.
Memorandum of leading to disclosure also there, your lordship.
What is recovered? Recovered also. It is in sense.
Yes, your lordship. Daudi jo tha backward turning banji Rossi has been seized in your lordship before this. Please that part. I am pressing your lordship.
File. Let me see.
Yes, place that part.
Yes.
Okay. I am pressing your lordship.
No, file it. I will record it. Yes.
Yes.
Just simply adjourn. Then counsel for the state to place on record the copy of the article. Copy of
Photocopy, your lordship, or not?
Yes.
Lordship.
Photocopy.
Yes, lordship. I will adjust this update one.
He'll give you a date. Just check it up. Yes. 30 also same, I think.
No, my lord, 30. My lord, 30, your lordship was pleased to call for the criminal antecedent last time. Earlier, it was rejected by your lordship. Page 36.
Yes.
Because in the meantime, my lord, my lord, I am in custody since 14/4/2023.
14/4.
Before
2023.
meeting my learned senior lordship, in this case, I have moved now CD is not with me, your lordship, and so far criminal antecedent is concerned, lordship. Related to many other date, your lordship.
22nd. Another matter is kept on that day. She will come.
22nd.
Yes, your lordship.
Oh, bless.
31, similar, I guess, what So 34 also.
34 also. 34 also. 31 and 34. Yes, 32.
Okay.
32. Non appears, urgent. Yes.
33. Not the second and philosophy. Disposing my application directed me to move after examination of materialities. The prosecution cases that the deceased was happened to be working under the petitioners here, the transporter, he was working with the driver. And on the date of occurrence, it is alleged that the petitioner's son, Deepak, and another accused, both took the deceased to their house in their motorcycle and left.
Where are the material witnesses?
Witnesses are sub the copy. Informant and another.
Have you seen it?
Yes, I have gone through. The wife of the deceased has clearly, when paragraph first, two graph has stated, but in the last part, he refused. I don't know the informant who was lost the affair.
He hostile on the informant with the PW3. He stated that Marat in chief. Malatia Lordship.
Which one? DW?
PW3.
Okay.
PW3. I am the informant of this case. I do not know the accused person standing in the dock. I also do not know the accused Virendra Yadav. Totally refused to identify the present petitioner. This is my husband. I have not lost the affair in the police station. My husband had stated before me that he was working as a driver under Virendra Yadav, to whom I was never seen on 16th.
This is the informant. Yes.
This is the informant. And why?
I read it. Next.
Thereafter, Malak, two unknown persons came brought to my
Come to PW1.
Pardon?
PW1.
PW1 is not a material witness, Malak. He is a evidence. He is not a material witness. He stated that my house is situated on the date of incident. I was sitting in the front of.
Who all are the material witnesses?
He stated.
Here is the present.
Coming in birth, PW4.
No, last time I rejected saying that let the material witnesses be examined.
Yes, sir.
Four witnesses were examined. Are you sure that these are the four material witnesses or any more witnesses are there to be examined?
They are the three material witnesses.
Also, so far, I've gone through the one system technology witnesses. So far, present informant is the wife of the deceased. His clearly represent daughter is also his wife of the deceased.
Yes, PW3.
The wife of the deceased.
He is not supporting.
So the case. Daughter of the deceased kindly class period 2 also. Period 2. Minor daughter is able to give the adduced evidence to the court. Is clearly stated your lordship. Lordship, period 2 lordship.
Yes, I'm there.
Yes, lordship. Then Udia is able to
The informant is my mother.
Yes, lordship. Stated. My father was not able to move, for which my mother requested the above accused persons to leave my father inside our house, and thereafter the accused person left my father inside our house and went away. Then, on being asked my mother and grandmother,
Yes, PW3 and 4 both.
please let me.
Let him. Why, I don't understand. This is no way approach. Somebody is arguing and you are.
On being asked, my mother and grandmother, my father told them that accused person named Virendra, you are also present person also, and Deepak had assaulted my father. I was also present in our home at the time when my father told that accused person Deepak and Virendra had assaulted him. Thereafter, my mother told me to call the accused Virendra to our home. I proceeded.
No, direct evidence.
Yes, yours.
No,
I'm completing. I proceeded to the house of the accused Virendra and asked about the reason why my mother was complaining pain. But the accused Virendra told me that I cannot do anything on the way to him. Therefore, I intended some values of the accused Virendra and found that my father was completely silent and was not able to speak. So I called my grandmother, who was outside our home for work,
Grandfather is also a witness.
yes, sir, but not been examined. So, it's but represent of this.
Yes, who is the witness?
Yes, sir, also.
Grandfather.
Yes, sir.
What is your answer to this? Find out, who is grandfather?
My answer, Marat, the material witness, Marat, the prosecution case rests on two types of evidence. One is the person
Is a direct eyewitness.
Eyewitness, again. It can oral dying declaration before my point.
EW2 is direct. She has said that I have seen it. My father was assaulted.
But you have seen my put, seen what to decode.
Assaulted. I have seen it. He was assaulted.
On being armed, you are the cost of repetition, you are also on being asked by father, my mother and grandmother, my father told them. It is the oral time declaration. So the case is that Virendra and another accused took the deceased to their house and left and took him to inside their house. Thereafter left the house. Thereafter it is alleged in paragraph 3 stated that on being asked by the mother is PW3 and grandmother PW4, my father disclosed. My father told them that accused persons, namely Virendra and Deepak, has assaulted. So when before
moving further, thereafter my mother told me
I was present at home at the time when my father told the accused persons Deepak and Virendra had assaulted him. So this is oral declaration before family members.
You read it, I can understand it.
Thereafter my mother told me to call the accused Virendra.
You are Virendra. I proceed to the house of the accused Virendra and asked about the reason why my father was complaining pain. Where the accused told me that I cannot say anything.
You can go home.
Thereafter I returned back to the home and so on. So Virendra and found that my father was completely silent and was not speaking.
Eyewitness to tell.
Yes. Father, grandfather.
Pahila sir, PW3, Ma grandmother, their examination PW3 and 4. They did not say anything. They did not support.
Who are the eyewitness now?
Eyewitness can do.
There is no eyewitness.
Grandfather.
After this, grandfather to the hospital.
Grandfather and I'll keep it pending. Okay.
grandfather seller. Here my friend is whether he is a material witness. My friend will ask.
From child witness evidence, it appears that the grandfather is also a material witness.
ঠিক ଅଛି ସାର୍ ରଖନ୍ତୁ ମତ ବୁଝିଲେ ତା ଚାଇଲ୍ଡ ୱିଟନେସ୍ କହୁଛି ମୁଁ ତାପରେ ଘଟଣା ପରେ ମୁଁ ଗଲି ମୋ ଗ୍ରାଣ୍ଡଫାଦର କୁ ଡାକିବା ପାଇଁ ମୋ ଗ୍ରାଣ୍ଡଫାଦର
27.
ଆଜ୍ଞା ଦେଖି ଦିଅନ୍ତୁ କିଏ ଗ୍ରାଣ୍ଡଫାଦର କିଏ ଅଛନ୍ତି ତାଙ୍କର ତାର ଏଭିଡେନ୍ସ ଅଛି ଗ୍ରାଣ୍ଡଫାଦର ଷ୍ଟେଟମେଣ୍ଟ କଣ whether it is relevant or not also and
Only bail application at least.
pardon
Yes.
35
Next, so 25. Yes.
Well, item 35 meter. Number 2.
So, enter appearance for appeal and lease the matter on 27. Yes, 36. Non-appears for the petitioner, lease the matter. Next. I just come. 37 chapter.
Fasting.
Hello, I did. I want to address the complaint of appeal particular to allow me to address the appeal particular to notice the kindness.
Lots of, I am reading the relevant portion of the allegation that
Say they have settled the dispute.
then I have not. 376.
Have you settled the dispute?
दुनिया है कि देखो एक person that is the allegation also.
498 and all.
490 in respect of husband and mother-in-law. So by presentation is the दुनिया है कि तांत्रिक.
He's not mother-in-law.
No, your lordship. We are not her husband, neither husband nor mother-in-law. But fact he is the gunya.
You have not included the informant also. You have settled.
वो particular man है आपके तरफ.
You say that you have settled the dispute. Have you settled the dispute?
Yes.
Yes or no, you tell me. What exactly you want to tell? You scared. I don't think you should scared in this court. You tell me whatever you want to tell. No problem. Have you settled the dispute?
Yes.
Dispute settle lagi. नहीं होता. Dispute settle लगा कोई ना कभी. Dispute settle नहीं ना. अच्छा military आर्गू करे तो military को कौन है? Your name is not there in the charge sheet. Then you be happy. Why are you telling me? See, there was an FIR. Okay. You are not the family member.
No.
Your name was there in the FIR. After investigation, charge sheet is filed. Charge sheet is not filed against you, against other people. How are you agreeing? You see,
I will bring the notice to the Hon'Ble Court by keeping investigation open.
whenever if at all it is filed subsequently, then you may have some grievance you file it. Today you don't have a local.
Shown as abscond lordship. So far, my Ranian friend is saying that not been filed against the present person. That is not correct.
Charge sheet also you have not filed going in and abscond.
No, that's not arrested lordship.
170. See, try to appreciate you. You could have filed a charge sheet.
Yes, lordship.
Against him showing him an absconder. You haven't done it. 173(8) is open.
Yes, lordship. Not arrested.
In the further investigation, you may, file the charge sheet, whatever. Or you may not file also. When the further charge sheet you will file, that time you will get the cause of action to challenge.
Yes, sir.
Today, as of today, no charge sheet is filed against him. That is his case.
Yes, sir.
What do you want to say? You tell me.
You can investigation is open till 8 or so. Yes, the bail application was answered. Bail was dismissed by this Hon'Ble Court earlier in 2023 lordship. And so far present petition for quashment and so
charge sheet is filed against how many accused?
Number 2. Against 2 persons lordship that against the husband and mother-in-law of the present petition lordship.
Yes. Where is his name?
Lordship, page 23 lordship kindly glance.
Not charge sheet. What is his name?
Present SK
Particulars of the
SK Tariff.
SK
Tariff. Page 23 last. Page 23 lordship, first para last 4 lines.
23.
Yes, lordship.
Yes.
The stipulated period of 120 days is going to complete on 12/1/2023, but accused persons, SK Tara, present prisoners, and Surjaman Jana are yet to be arrested. Hence, I made fair to SP Balesur to pass necessary orders to submit charge sheet by. Therefore, also as the stipulated period of 120 days is going to be completed on 12/1/2023, and the accused persons, SK Tara, will be arrested. And I submitted charge sheet at section number 3 under section 492, 294, 323, 342, 417, 2140, not 362N, 5030 IPC, and 4 DP Act, and section 5.
You have to, go and surrender before the IO so that investigation can be carried out. Yes, right on. Petitioner is petition is challenging the criminal prosecution, entire criminal prosecution initiated against him. initiated against him in connection with the FIR number, Jaleshwar PS case number 169 of 2022. After investigation, charge sheet in the present case has already been filed on 10/1/2023. Since the petitioner petitioner is alleged to be absconding, the charge sheet has not been filed against him, keeping the further investigation open under section 173 bracket 8 of CRPC. At this stage, petitioner is seeking indulgence of this court for passing of the charge sheet. Since the charge sheet has not yet been filed against the petitioner, liberty is granted to petitioner, no cause of action as such exist in favor of the petitioner, in favor of the petitioner. The petitioner has been absconding. Therefore, he seeks liberty of this court to allow him to appear before the investigating officer on or before 30th of November. 30th of November and 30th of November to participate in the investigation process. He may appear before the IO on or before certain days. Till then, no course shall be taken. Let him go and appear, otherwise it will be in the limbo. Till 30th of November, I am protecting him. Go and you go and appear before IO, and they may file a closure report. And till 30th, no course action. Yes.
38.
38 might not extension of time.
Extension of time for?
My lord, for Belgium matter, getting before the surrender before the London court will lodge.
How many times you have sought for extension?
Lordship, the second time lordship.
I will not allow second time.
Lordship, then this order that annex one, my lord, due to the severe chest pain, he is not surrender before London court will.
2013, the NBW was issued. I gave you time for appearing by 30th of June 2024. You didn't appear, and thereafter you application for extension. I have extended up till 15th of October. Again, you are asking for it.
Lordship, due to the chest pain, so do not appear surrender before the surrender.
I don't know. I mean, somewhere you have to, I have mentioned it. It is made clear that no further extension shall be given in this case.
Lordship, and petitioner
What will I do with this order now? Last time I said that no further extension. Last time I said no further extension. What to do? I can't help it now.
any cost imposed by the law.
What do you say?
You are not able to execute granted in last chance also.
But you should have executed the warrant. You have not executed. If you do, if I will not allow, this warrant will never be executed. That's the another problem. I'll impose heavy cost. Heavy cost. Which police station is this? Mahila police station. Kotak Mahila police station. Kotak district Bharat.
Kotak Mahila.
Petitioner had approached the court seeking cancellation of NBW issued against him. NBW issued against him by the order dated 23/2023 by the court of SDGM Cuttack. By the order dated 6/5/2024, the NBW was cancelled, subject to the petitioner appearing before the court on or before 30th June 2024 and resorting to the remedy available to him under law. The petitioner defaulted in appearing within the stipulated time frame and moved another application being IA number 2471 of 2024. By the order dated 17/9/2024, again extension was granted up till 15/10/2024 to appear 24 for appearing the petitioner before the trial court. Within a condition that no further extension shall be granted. The petitioner has moved the present application. Present application. When is that application?
I know.
Where is that application? In the application, what have you written? Nothing. Chest pain, what pain, where have you written?
Annex. Annex to one, the medical certificate.
Where is that?
It's in page 9.
Page 9.
Please.
9 plus sector 7 CD doctor and certificate.
I have annex. Annex to one.
These are all fraud certificates. And you'll invite problem for the doctor also. If I issue notice, then he will also be going with it. And both of you will stay in the same cell. What kind of the medical certificate?
Again, extension was granted till 24 for appearing in petition before the trial with condition that no further extension shall be granted. The petition should move the present application.
Present application seeking further extension on the ground that he has been suffering. What sufferings?
Chest pain.
He is suffering from chest pain. Okay. He has enclosed a prescription. Prescription, what is this? A certificate purported to have been issued by a doctor, by a private doctor. The certificate, although inspire no confidence to be relied upon, but taking into consideration the statement made by the learned counsel at the bar, I'm inclined to extend the time for surrendering. Extend the time for the petitioner to surrender before the court below as a final opportunity. Accordingly, the petitioner is directed to surrender before the court below on or before 30th of November so subject and resort to the remedy available to him under law. This extension is granted subject to the petitioner paying cost of rupees 10,000 before
1,000, he is.
I will increase. Fraud certificate you have given, still I am giving it. In the High Court, you are using a fraud certificate and you are asking 10,000 rupees in the district bar association. Then I'll summon the doctor. Shall I summon the doctor? And judicial proceeding has some sanctity. You can't bring any document and place it in the High Court and get away with that. 5,000. Yes. 5,000. Yes, next.
Awaiting status.
Awaiting?
Postal reports.
Whatever.
Notice not sufficient. Place this matter after 2 weeks, Your Lordship.
2 weeks.
In the meantime.
Press notice.
Press notice, my lord. Notice already.
Notice awaiting. Awaiting notice, service of notice on opposite party number 3. 2. List the matters also after 2 weeks.
Good.
Okay.
3, sorry. 3, my lord.
3, Three.
Beg pardon, my lord.
3, yes.
40.
Yes. Yes.
The petitioner is on VC.
What is this?
Last occasion, also the answer document getting a lot of information. Last again, lordship directed both the parties to present. And so per after lordship direction, my client, informant, is present with lordships in court. Now, what is this case is about?
Section of the entire proceeding, say on the basis of.
Where is the first?
What she required is that annexure 2, page number.
Charge sheet has been filed?
Lordship, charge sheet has been filed against only one.
498A.
Lordship.
Charge sheet under which provision? Where is that?
Under section 4.
Confirm. For 498, 294, 231, 230. My lord, my problem is, my lord, informant is present, my lord, informant, lady, my lord, right? My lord, she is not interested, my lord, to quite the proceeding because there are earlier discussion was going on husband and wife. That proceeding, he will file a divorce proceeding. But what is that name? What is that name? Kannapur chain. Ye Karnataka. Pushpala. Yes. What do you want?
Mukesh Udham.
No. What to do? Revive the husband will file. This is saying, if your husband will file a divorce proceeding, thereafter we will revive the prayer. After divorce proceeding, if the cause of action subsisted in the case. Yes. My name may be declared also the opposite number 2. Why don't you settle if
Definitely will take steps, Lordship.
yes.
Obliged.
31.
May I please, my lordship, I mean DC.
Yes.
Lordship, noting the neither AD nor undelivered notice returned back from the opposite party till now, Lordship.
Not delivered, told them. Not delivered, told them.
So you take one more attempt. Press attempt, steps shall be taken by the opposite party petitioner to serve opposite party number 2. Leaves the matter. Yes.
Lordship, in order to be continued, my lord.
We want to continue. Yes.
Very good.
It is inadvertently that is written.
Sorry?
Inadvertently that has been tied to the state of Odisha.
So it is a complaint for civil.
Where?
It has comes so much more. Correction.
Correction of order dated 2110.
Yes.
The reason stated in there. Sorry?
Rajiv Kumar Purohit Hobagat for the opposite party. So that it has been tied up set up.
Which order you want clarification?
That is 2110-2024.
2110.
Yes.
Which paragraph?
Opposite party.
Opposite party.
Opposite party Rajiv Kumar Purohit Hobagat state of Orissa he is. So that is,
Rajiv.
so another extension of that because by
For the reason stated in the application, the modification is allowed, and the cost title of the case appearing in order dated 21/10/2024 is corrected to so. And for the as because of the confusion, as stated above, the extension, prayer for extension of time is allowed. Grant 4 weeks time, 4 weeks time, which was 4 weeks time granted to the petitioner to comply with order dated 23/7/2024. 2024 has expired, hence he seeks for further extension. Accordingly, the time is extended up till 30th of November. To comply the order dated 23/7/2024 passed by this court. Passed by this court. Okay.
Opposite party appearing UC Mishra and assistant. Oblast.
43.
Amit.
There is also correction.
First order to naam Shukman. Second order it about
43.
The number has to
correction.
better.
What correction?
Number 1.
142 it is 1142.
Yes, correct.
correction for the reason stated in the application. Application is allowed, correction carried out, yes.
44.
On behalf of Mr. H.S. Mishra, can you pass over?
Yes, person.
45.
He has come, he has come.
Well, also you take out that 44, I'm sorry.
44. Yes, come.
Petition for passing of the cognizance process, you will also kindly see.
Yes.
From paragraph 4, whatever the affair, final report was submitted, and UD case was registered, and the entire the yes, diary.
Yes.
And the UD case, the itself will refer that there is absolutely nothing, rather the petitioner took, gave help to the deceased and who died in natural death, that as per the prosecution report.
Yes.
But thereafter, on the protest petition, without any basis and even without any evidence that there is a homicidal death, the mechanically cognizance has been taken.
Okay.
You'll also kindly see the final report submitted by the police as well as the UD.
Yes.
Detailed the investigation has been done and the police has given a detailed report as to how the
All four of you, huh?
Well,
Yes. Let us see the final report.
You'll also kindly see the final report as well as the UD case registered.
Page 19.
19, read it.
Everyone, you don't have the copy. If she wants to see.
Page 19 is the final report.
Yes, I am reading that.
And the written report of the complaint, earlier such. The Human Rights Commission of High Court the proper inquiry of the above notice case. Filed before the Human Rights Commission and Hon'Ble High Court, Orissa for proper inquiry. The above notice case was registered and investigated. During course of investigation, the inspector later came to the certain that when the late Vishnu Priya Sahu was suffered an paralytic attack, became completely bad. Radharaj Mahapatra came to her house and provided food, shelter, and every possible medical care, and took her to BM Schools Hospital in Burla for her treatment, and returned to his house with Vishnu Priya Sahu. And
Where is the medical report? It says that it is natural death because of the cardiac arrest.
This was the report. That
is the final form. The cause of the disease is a natural cause. And there is no suspicion of fraud. Okay, this is the
mistake of that.
okay. Complaint, let us see.
The dead body was sent for PM examination. Substantial contracted substantial opined that the cause of death of the disease due to natural death. That is the seventh line from the bottom. Eighth line. Thereafter, the rituals took place and everything.
What is the introduction of this court the FIR says?
Because it was natural death, there was nothing but out of.
See, page 20 scanning, hard copy is there. How it is scanned? Nothing is put to it. Who is appearing for opposite party number 2?
So Devapatra Ratna had appeared.
Korea South.
Devapatra Ratna, SS Mahapatra, SK Panda. For OP number 2.
Korea South. 21.
Without going through the entire record, mechanically cognizance will be taken by the randomized.
202 inquiry was conducted.
I got the medical report.
It says the natural death.
Natural death.
Natural death. Therefore, you file a claim report.
And also all the evidence, except that informant, all are supporting the.
So therefore, in the protest petition, what is there? Nothing except the statement.
Yes, yes.
Statement is against the documentary evidences.
Yes, yes. Absolutely. I have launched the entire record. Report also.
How will you sustain the prosecution against them?
Yes, the medical report also shows that it is a
Who is appearing in court because the informant has to be heard.
Private opposite party appeared to advocate that Ratham, Mr. Mahapatra and Panda.
I'll let you. No, I'll urgent it. Let them, if second call they may come. You don't come. I'll urgent it, but if they come, then I'll just see. Otherwise,
Correct.
they may come in this.
They should be heard.
So that I can fix a date for you.
all the.
It is nothing, unless this prosecution is, except the statement of the informant. That statement is also taken care of by the police.
Yes, yes.
Doctor is examining, inquest report has come on record.
Yes, yes. That will be final report to find that they mistake of.
And the trial court taking cognizance on the basis of the statement only, ignoring the other thing.
Expanding the allegation made in the FIR that.
Nothing.
Yes, yes.
I'll pass it over, I'll give one charge, otherwise I'll pass an order. Unnecessary pending from 2017. Yes.
In the last occasion, I had some difficulty. I waited for adjournment.
There is nothing. 2017 it is pending.
So I did not be present, man.
LCR is also there. You can check it up. Huh? You can assist me. Yes. Yes.
I did not be present, man.
You may not be present.
Okay.
If I may please, my lord. In the year 86, a complaint case was filed for non-payment of provident fund dues.
My lord, just now I received a copy of I number 2958 of 2023 along with an additional affidavit.
What is this I?
I for production of related documents. It says please to direct the opposite party one to produce the records related to the provident fund dues. Provident fund dues.
They may have been made long since, so I have given some documents. So 86 of Barambo Kacha Karkhana. School report. Say Bonza, say 86 the director we Marisalan, one of the director who ceased to be a director now. See Tankanar Kesta 86 payment offense of the 6 months. No, 1,000 tanga fine. Or
anything survives in this matter.
My lord, I have asked them to give instruction in writing as to the present status of the case. Just now I have given them.
No, that's right, but see, these are the cases pending from 1986.
One thing is, if
1986, just imagine.
Yes, my lord.
What will you get out of it?
My lord, one thing is, it's a case of 98 filing imbue was issued. Thereafter, he remained absent, absconding, and in the year 2022, he approached by filing the CLMC number that 497 of 2020.
You have challenged the order dated 28/12/2021. Where is that order? Let us see that order. 28.
that is for actually, my lord, that's for discharging, technically not maintainable. Only with regard to 482 for preventing abuse of.
What exactly, what is your grievance? You are given.
My lord, they have not paid.
How much?
My specific.
What is the amount you tell me? Come to the point.
That is 91,950.
I'll tell them to pay and finish it up.
They have already received that.
Even late payment also invites punishment.
Don't try to be more ambitious now. This much amount they will pay and close it. 1986 case, if you prosecute, you will not get any. You will waste more money on that.
I have asked that specific instruction on the matter so that it can be disposed of.
I see. Either I'll send to mediation center. It
was sent and it ended up with failure.
ସେମାନେ କହୁଛନ୍ତି ଡକ୍ୟୁମେଣ୍ଟ ଡିସ୍ପ୍ୟୁଟ ଅଛି ନାଉ ଦେ ଲେଟ୍ ଦେମ୍ ଟେକ୍ ଇନଷ୍ଟ୍ରକ୍ସନ
Payment
ଯଦି ହେଇଛି what is the amount you tell me the entire disputed amount you tell me I'll put it to them they will deposit and I'll finish it up.
Total amount is 91,950.
Then from 86 you are prosecuting for 91 he is ready to pay. I'll ask him already paid. It's already paid.
Regards for law, rule of law. He is outstanding from 98 till 2020.
For 98,000 anybody will be absent.
My lord,
If you after his blood for 9,000
he doesn't deserve any sympathy. Let him check it out next week, my lord.
next week.
Lordship में fixed date.
Try to be practical. It is burden on the courts. And you won't get anything out of it.
It is poor workers.
That's right. Therefore I'm saying, they say that they have already paid. I'll make them to pay once more. Finish. Take some money and finish it up. I'll quash everything. And that will be more beneficial to the worker. They will prosecute. Nothing will happen in this case. He definitely will be acquitted. 1986 case. Try to be practical and take money and finish it up. You ask in the seek instruction and put it next
Let's, I get instruction on my.
Yes, of course.
Next week, 22nd.
21st. Seek instruction will come to put an end to it.
Yes.
What are the terms, whatever terms they have. I'll put it to them and finish it up.
Okay.
Yes, interim order to continue. Interim order to continue.
46.
May I please, your lordship. Challenging the order of cognizance under Annex 4. Annex 4, my lord, the petitioner has filed this chairmanship. My lord, initially FIR was registered against one Vijay Kumar Rai, against one Bipin Kumar Rai and Manasa Rai for the alleged offence commission of offence under section 465, 467, 468, 477A, 420, 294, 506, 120B of the Indian Penal Code. The name of the petitioner does not find place in the FIR, but subsequently the present petitioner, who was the Gideon RI of the locality, has included as an accused. Where is the charge sheet? My lord, charge sheet.
That matter was dismissed for non-prosecution on 5/7/2025. Then it was restored. So therefore, the office has not supplied, thinking that has been disposed of.
No, you have challenged the cognizance order. Entire proceeding, cognizance as well as the, where is the charge sheet, entire proceeding, it's all right. My lord, charge sheet is not. Only FIR, annex FIR and the entire proceeding pass. Let it next week, my lord, I will supply all the. This matter is pending since 2022. It is wrongly dismissed in default. It should have been dismissed on merit on that day. What kind of petition is this? My lord, this is a transfer bill, my lord. My lord, he has not filed anything to be supplied. Nothing relevant is filed. It will be useless for you. Nothing relevant is filed. I will supply all the. Supply the copy, file additional document. My lord. Okay. My lord. Additional document, huh? Please. नहीं 2 weeks for this. No, next anytime. Matter was dismissing the fall. You didn't bother. No, thereafter. When this matter came to this court, you restored it. And I found there is nothing is filed with it. And now it's so urgent. Tomorrow, Monday, I will file the entire documents. I will copy this. No, Sunday especially I will seek for this matter. No, Monday. So urgent. So urgent. I will file all the documents. You file all the documents, it will come after 2 weeks. Fix up a date so that. Okay, after 2 weeks. There is nothing in this matter. Better you settle with me.
Sir.
And supply the copy to Mr. Mishra also. Yes. Internal order. 47, sir.
Challenging order of cognizance.
This is an order challenging cognizance, my lords. It's purely a civil dispute, my lords. Arbitration proceeding is going on.
1 CC case.
Your lordship, the main dispute was there was a non-exclusive agreement with the opposite party number two. My lords, we are a medicine company, my lords. If your lordship sees Annexure 3 at running page 26,
Yes,
grant of distributorship is at clause 2.
yes.
The company hereby attempts and designates the distributor as the company's non-exclusive distributor of the products in the territory for the term as defined below. So it's a non-exclusive agreement. Now we give certain we make certain other distributors in that area. Now it's a non-exclusive agreement. He files a criminal case that we have cheated him. Anyway, thereafter there is an arbitration. Arbitration clause, if your lordship sees,
Yes.
page 34, arbitration.
Everything going on.
20, yes, any and all disputes or controversies arising out of a connection, the seat of the arbitrator shall be Mumbai. And my lords, already arbitrator has been appointed.
Yes.
Time and again, appear
And he has appeared before the arbitrator.
making allegations of.
He has made allegations against the arbitrator for which there was a change of arbitrator. All this has gone on. There was a change of.
Let us see the complaint then.
Yes.
Let us see the complaint. Whether it is.
Annexure 2.
Yes. Let us read it.
Yes. Where are summons? Page 20.
22.
Date, time, and place of occurrence. Accused, lordship gets page 20. Accused company number 1 has collected 6 numbers of checks directly from Dr. Ajay Das bearing 41 such and such. Motiganj Baleswar, that is again, which again included the cost of the products in the invoice of the complainant dated 22/12/2014. Similarly, 6 numbers of checks have been collected from Dr. P.K. Nanda, bearing number such and such, and check number all drawn in favor of accused company number of accused company.
It is regarding some check issue.
Yes, well, they have issued checks for various products they have taken.
At least sold these products to these people.
We have sold all our products to these people, Dr. Nanda and Dr. Ajay Das. Now, accused number 1 has also collected 6 numbers of checks from one Dr. P.K. Tripathi. Again, we have sold these products in favor of the accused number, which mischievously included the cost of the product in the invoice of the complainant dated 17/1/2000. All the checks have been collected in Bhubaneswar and the complainant resides and carries his business in Bhubaneswar. Three facts of the case. The complainant is a proprietary concern being represented by its sole proprietor, Dr. Trinathkar. The accused company number 1 dealt with trading and supply of medical equipments, including dental equipments under the brand Care. The complainant was a distributor of the accused company number 1, engaged in marketing the products and promoting the sale of the accused company since year 2014. There was an agreement between the parties that the claimant may directly contact a customer where the customer is an organization or institution, but violating the basic terms of that agreement, the claimant has a number of times directly approached customers, doctors in the city of Bhubaneswar and other parts of Orissa and has supplied materials to those customers, illegally collecting money from them, violating the provisions of VAT, CST, ET, but mischievously to show that the transaction has been done as per procedure. The accused company number 1 has included the cost of the products in the invoice of the complainant, claiming the money from him. 3 numbers of endomotors, models number such and such, a medical device used by the dental practitioners to the RCT. The buyers were Ajay Das, P.K. Nanda, P.K. Tripathi. As per the scheme of the accused company, payment has been collected by the accused company from each buyer in the following denominations: 10,000, 9,000,
You come to this page 24.
Page 34.
24.
24.
24. This is the case.
My lord.
4. The accused company 1.
The accused company number 1 has subsequently sold the company's business of trading, supplying of medical equipments, research, analytical instruments and related consumables under the Kavokeri operating brand to the accused company number 2, Noble Biocare. And a business transfer agreement has also been executed between the two on
So this
31st
is
July
what is the real
2019.
issue is. Who
Whereby
is
the accused company number 2 has not only purchased the business.
Yes, yes, I understand. Yes.
Yes, my lord.
It's completely transaction arising out of a contract
Contract, yes.
where arbitration clause is there.
Yes.
And you resorted to arbitration. What else you have?
Yes.
How can you prosecute him for that? Where is he? Who is appealing for opposite party number 2? Mr. Tirnaskar, proprietor.
High Court of Bombay, High Court.
Who is appealing? Nobody.
Abhijit Mishra and K. Rajwa.
Huh?
High Court, Bombay, High Court of Order.
They have to be heard.
Well, because the Bombay High Court also, he filed an application for change of the arbitrator. Bombay High Court again allows that application and so okay, we give another independent arbiter. He recused because various allegations were made against him, but he goes on litigating Manoj.
A chance, there is no chance of, obviously, no chance of settlement arbitration is going on and all. Anyway.
Mediation has already failed. He had tried mediation.
Okay, and none appears for opposite party number 2. The matter was partly heard. Mr. Milan Kango heard Mr. Milan Kango partly since none appears for opposite party number 2. Matter is adjourned to such and such a day and interim order to continue.
Okay.
Mr. Vishal has lots of it. They will come after 3 weeks. 2 weeks, yes. By that time, something may happen in the arbitration. It is arm twisting method, that's all.
Well, he is making false allegations against the arbitrator. Still, then the arbitrator recused himself. They went to the Bombay. We went to the Bombay High Court. Bombay High Court changed the arbitrator. He has participated in it.
Whatever you get there only.
Yes, sir.
It is money. It is basically money claim, some business transaction.
Yes.
You have promised something, and you have given this to other franchisees and all.
His main case is why am I approaching other doctors and other Maloj? They have given him a non-exclusive agreement. Non-exclusive Maloj, I can do my own business.
Yes, yes. There is no restriction in the
Restriction. Obligation.
Yes.
49.
My lord, may it please your lordship, my lord.
Yes.
My lord, I am extremely sorry, your lordship, because of some medical difficulty, I have to appear in VC, my lord. This case, your lordship, I have already.
If there is no urgency, you can argue later on. Why are you training yourself? I'll put it next week.
This matter can be disposed of, your lordship.
If you are not well, why are you training?
No, my lord, I have some other medical difficulties for which I have to stay. But this matter can be.
Yes.
In this item, I am brought opposite party on behalf of my senior. I prefer the adjournment next week.
The opposite party in any case is asking for adjournment. Put it next week.
May I make a small prayer? I will not take much time because he is praying for an adjournment. This matter, your lordship has already heard that this is the brother-in-law tagged in domestic violence case, wherein husband has been acquitted in 490-day case. Divorce has been allowed by the husband at the instance of husband against the wife. So your lordship also said that if nothing could be done to husband, tagging brother-in-law will not solve any purpose.
I've seen it. Therefore, there is an interim order. Let it continue next week. Interim order to continue and list it. Yes.
So
in this case, I have I filed them in my file.
Okay. So
let it come on Monday, your lordship.
Not Monday. He is entering appearance now. You have to give the copy and he will get ready.
The lawyer was there, Mr. Behra was there. I have solved him all.
He is now entering appearance.
He is on behalf of him.
Yes.
You have filed Bakawatama?
Yes.
You already filed?
Yes.
Why are you saying that I filed it?
I know yesterday.
Yesterday you filed Bakawatama. Okay. List it up. Yes. If you wanted to continue. Yes.
Item 50.
This matter, I have taken fresh steps, notice has been delivered. Even since the rise out of NIA Act, take a notice there. I was proposing for mediation, but both the participants settled.
Where did you take a note?
Opposite party, my lord.
What did you take a note?
One person.
Huh?
15 lakhs, man.
If it can be sorted out between the parties.
Right.
Send it to me.
The councils appearing for the party conjointly states that submits that the party would prefer to go for a mediation and try to settle the issue out of court. Regarding it to the statement made by the councils for the parties, the matter is referred to where High Court. High Court Mediation Center. Same court. Mediation report is the material.
In that time,
I'll have to stay the proceeding until during the mediation report. Simply stay the further proceedings also. Yes.
51.
Yes. Service के हाथ petition. Sufficient. It's sufficient. Let us wait.
You must have appeared.
Nobody has entered appearance. Although the service on opposite party number 2 is sufficient, but nobody has entered appearance appearance on behalf of opposite party number 2. In the interest of justice, leave the matter after 2 weeks, interim order to continue.
52.
Similar matter, 18th November.
19th?
November.
Connected matter.
No.
Connected matter is listed. Okay. Use the number. Connected matter listed 19th.
622 of 2000.
Yes.
Lordship, it is the same matter of prosecutions.
You will come on 19th, we'll see. Yes.
63.
May I please, your lordship? Where the petitioners are the in-laws and the OP number 2 is the that daughter-in-law and sister-in-law, my lord. Your lordship was pleased to send it to mediation. All the in-laws came, my lord, but the OP number 2, through our counsel stated that she is not prepared to cooperate with the mediation. Mediation failed. Report is there, my lord, before your lordship. And on last occasion, on 26/9/2024,
yes.
Last opportunity was granted to the OP number 2 because the council was also absent to address the honorable court. This way we are harassed that the petitioner number 1 is the mother-in-law.
Yes.
Second is the sister-in-law who is working at Bangalore. Third is married sister-in-law who is in Fargad, but her husband is a police inspector and working in Noapada. And also been embroiled in case under section 12 of the Protection of Women from Domestic Violence Act.
Yes.
Therefore, my lord, they have approached your lordship for the passing of the proceeding against them.
And what are the
important first of the dispute is between the husband and the wife. They are blessed with the child. Child is with the husband.
Husband is not.
Husband is not the party, my lord. And the married sister-in-law, brother-in-law, and mother-in-law, they never shared any domestic relationship.
Where have you said that? Let us see the material.
My lord.
Yes.
My lord, I have, your lordship may kindly sit. The relationship, my lord.
What has happened to the marriage? Marriage is thing together.
Wife has filed a divorce petition also.
Okay.
It is in Bhubaneswar, transport and Bhubaneswar.
Yes.
And my lord, 2 criminal cases he instituted. In charge sheet, only husband has been charge sheeted, not these in-laws again. So there is no question of any torture. 498 cases are annexed. But as annexed 2, 3, 4, and 5. There the present petitioners are.
What we'll do is, in these kind of cases, time is really time will heal everything. So wait, I have passed the interim order.
My lord.
Further proceedings here. The counsel for the petition submits that the mediation has failed, and the Orissa High Court Mediation Center has placed a report dated 20th
September 2024. Intimating this court that due to non-cooperation on the part of opposite party number 2, the mediation has failed. Mediation has failed. Leaves the matter for non-appeals for opposite party number 2. Leaves the matter for final disposal after 4 weeks. There is an interim. When is the stay order?
That stay order was granted on 24/4/2024.
The interim stay order pass on 24/4/2024 shall continue till further orders.
54.
The petitioner is challenging the order taking cognizance under running page 90. It is a clear case of offence on section 420/468/34 of IPC.
Yes.
It is clear case of your lordship the civil in nature. Civil remedy is available. Your lordship may kindly see the annexure under annexure 6. Vikram Kavala.
Lordship, I am on BC, Your Lordship. I am appearing for OP number 2 on behalf of Mr. MD Pradhan, Your Lordship.
Yes, yes, sir.
Yes. Your Lordship.
Your Lordship, I need some time for filing of reply, Your Lordship.
What happened? Mamu, accused number 4 and 5, 3 and 4, and accused number 1 is the brother-in-law. Accused number who are the student, accused number 3 and 4 sold out the property of their share, and the allegation under annexure to your lordship complainant, your lordship see. So complaint petitioner lechanti.
So there is an interim order. He is asking for adjournment.
Yes, yes.
Yes. The opposite party number 2, huh?
Your Lordship.
Mr. S. Sahu, Lieutenant Counsel for the opposite party number 2, seeks an adjournment to file response to the petition. Leaves the matter after 4 weeks. The interim order shall continue till further orders. Yes.
55 one thing. What title the petition number 2 of father nanta bhuli jaichi. I mean permitted.
You correctly did hard copy there. Yes.
55. May I please? And for petitioner, petitioner files this application for quashing of the proceeding by the GR case number 1860/16 pending in the court of SDGM Cuttack Maral.
Yes.
Divorce already been allowed, and both parties have filed a joint affidavit stating that
wherever they can come.
No, my BC direction was there for
Your Lordship, I am appearing.
Yes,
I am appearing on behalf of wife. Your Lordship, day before yesterday, my Lord, I was directed to appear on BC. There is some difficulty. Even if my Lord, they have not appeared, Lordship, I beg to submit here. Your Lordship, kindly see it. No, not cross without the Your Lordship, kindly jump to one sentence I have subsequently made. It is a compromise which has been made whenever my Lord, the diverse proceeding was pending.
Understand it was you are trying to say in the competent of court of law it has been there. Yes, and there is a quashing there
is also judgment of this honorable court and several.
Why judgment? Why can't they come? Why judgment?
Because she has married. Married, she has been very difficult.
She can appear online.
And there is certain yes, there is certain problems that which cannot be.
Has she married somewhere else?
Somewhere else. So that is
where is the accused? Bring the accused.
Yes,
at least bring the accused. Yes. See, I can understand that if that girl has separated,
yes, my Lord,
and she married somewhere else.
Objection made in the
asking her to appear may create some problem in their right. So we should not insist to create problem for her.
That was in your.
But see, you have settled the dispute. As a part of court record, I can rely upon that court record. At least spare this girl. Where are the accused? Accused has to be there.
I bring
them.
Bring him.
2 o'clock.
Yes. No, my Lord.
Let them appear and initiate and finish it up. Why unnecessary meeting? Ask them. 2 o'clock. I'm talking about.
No, next day Asperivan join kari parivan, my Lord. He is also working in outside, my Lord.
What is it? Atma Ranjan.
Yes, my Lord. Address, but he is.
Ask him whether 2 o'clock he can appear. Ask him.
Yes,
if he appears through VCR.
Yes, ma'am. Yes.
Close it. Unnecessary. Why unnecessary?
My junior will be there, you Lordship.
Yes, no problem.
Yes, ma'am.
Ask him, because it's a 498.
I am asking.
They are separated.
Yes, madam.
Ask him.
Yes, madam.
Tell him to appear through VC.
Yes.
Wherever he is there, he can appear. What is the problem? Yes.
Reply.
56.
56, my lord, as per the information of the due to illness, my lord, okay to counsel is not there. It will not appear today also. But they have filed the, is it not a passing basis of compromise?
Who is not there?
OP2, the informant counsel.
The counsel for opposite party.
498,
He is asking for adjournment. Counsel for the opposite party number 2 is stated to be indisposed. Hence, adjournment is sought. Leaves the matter short. Yes.
57.
57, your lordship, is the on behalf of Mr. Manmohan Patnaik. He has filed Bhaklatna, my lord, just 14/11/2024 today. He
For opposite party number 2 and 3.
His name may be mentioned in the cause list.
Manmohan
Patnaik.
Mr. Hon'Ble Patnaik entered appearance on behalf of opposite party number 2 and 3. 2 and 3. His name may be reflected in the cause list. Leaves the matter for hearing.
Urgent halla, I may appear call.
Yes. Adjourn. Yes.
58.
Please, lordship, my lord, this is same case 53. These are the in-laws, my lord. Wife has filed domestic violence act case on the.
Let stay continue.
Your lordship, kindly pass the interim order.
Interim order is there?
The interim order was there to move for an adjournment.
No, interim. Stay up further.
Further proceeding.
Stay up further proceeding. Yes. If you don't want to settle, let it lie like that.
So, by the divorce application, here the husband.
Here, there is no order for settlement, my lord.
No, the other, okay, this is, they are different.
But in anticipated their application, mediation was directed by this honorable court. It
Yes.
said, now wife has filed an application for divorce. And this 12 section DV Act, we are the in-laws. Brother-in-law.
Any order was passed, interim order?
Interim order to move for an adjournment.
No, interim order is proceeding. Any interim order is there in his favor.
No, it was not only to move for adjournment.
I am asking something else, adjournment.
Further proceeding stay was not granted.
I am asking something else. You please listen and let me complete the full sentence then.
Sorry.
In DV proceeding, whether any interim order in his favor, in her favor is there or not?
Not.
There is nothing. Because if I stay the proceeding, the interim order is also will be stayed. Therefore, I am saying. Are you sure that there is no interim order? What is this case? DV proceeding.
We have been called upon to file our objection.
What is the stage? Do you have any idea?
This matter, appearance.
Then now, same arrangements continue. Interim arrangement.
They will file.
Not stay, at least pleading and everything should be over, so that thereafter I can stay. Yes.
Interim order passed.
Interim order passed from secretary to continue. Yes. Yes.
That item number 50, your lordship rightly state and refer to mediation. I am also ready to run. That item number 50, your lordship referred to mediation. My lord, I only pray mediation be held at Bhubaneswar because parties can be easily for convenience of all the parties. Because parties are, one is from
matter, I don't know.
Item 50, my lord, the check bounce matter. Check bounce matter, item number 50. My brother was there. Mr. Maharana was there and my friend was there.
You want to go to Bhubaneswar? 50 for the Bhubaneswar.
Your lordship rightly referred to mediation so that
something comes out, it's all right.
yes, it will be solved because matter they are ready to pay and ready to accept.
Some installment or something.
No, but only mediation will be easy for both parties.
Yes.
Pardon, Lordship, item 59, my lord. The mediation is supposed to be held on 22nd of November, my lord. Your item 59, that may be kept.
59 mediation matter was referred to mediation. Mediation process is going on. I think this is the matter awaiting mediation report. in December. Yes, yes, sir. Scrutiny. ठीक है? Yes, sir. Obliged jurors. Take it up at least.
Number 10. 590 by 21.
Which I right. Okay.
Deep level.
Yes. Yes. Is there now? Yes. See, I told you, if it's there, it will be finished now.
Yes, madam.
Yes. Yes, 55.
5 minutes.
Where is the decree? Divorce decree?
Madam, decree is under annexure, page 24, madam.
Huh?
Page 24 of the judgment, madam.
24.
Yes, madam.
Okay. What was the terms of settlement? How much you?
You can kindly turn to page 28.
You just tell me 28, na? 20.
Also at page 21.
No,
Para 3 and 4.
what is the alimony?
Alimony is no,
Anymore.
no,
Not
no alimony, madam.
Okay. Right on.
Para 4, no alimony.
Where does it say that this settlement you just told me?
Page 24, 28, my lord.
28, yes.
Top parameter. It is admitted by both PW1 and RW1 that their marriage took place on 9/2/2010, my lord, as per Hindu rights and customs in their evidence.
No, come to page 21. You have said that.
Yes, madam.
DVKs and so and so, and James Kotak so and so, and so on.
Yes, madam. 21 no bottom re lekhichi. Now joint affidavit bottom re achi. All the proceedings pending in the different courts.
Annual, right. Right up. At the instance of opposite party number 2, FIR number so and so has been raised against the petitioner. The allegation against the petitioner is so and so. After investigation, charge sheet in the present case has been filed on 21/4/2017 for alleged offence under section 498, capital A, 323, 325, 406, 307, 34 IPC. I read with it 4DP. When the trial was going on, when the trial of the case had already been commenced. When the matter stood thus, the parties have settled their dispute. And pursuant to the settlement, they filed a joint affidavit before the court of before the family judge Cuttack in CP number 473 of 15 in 15. The same case was filed by the present petitioner seeking a present petitioner under section 13(1) small a and 1 small b of the Hindu Marriage Act for dissolution of the marriage between the petitioner and opposite party number 2. The affidavit, in the said affidavit, the following averments were made. Page 21, para
5. Para 5, bottom.
Para 3, 4, and 5. 3, 4, and 5. Relying upon the said settlement term, the family judge Cuttack has allowed by its judgment dated 10/2/2022 allowed the divorce petition and dissolved the marriage between the petitioner and opposite party number 2. Okay. Opposite party number 2. The petitioner has filed the present proceeding seeking quashing of the entire proceeding on the basis of the settlement terms. The petitioner is present in the court through virtual mode and represented by his advocate, who identifies him, and he has filed also the self-attested copy of the Aadhaar card to establish their identity. The opposite party number 2 is not present in the court. Learned counsel for the petitioner submits that the opposite party number 2 has already married elsewhere and settled in her life. However, she is represented by the counsel. The counsel for the opposite party number 2 submits that the opposite party number 2 has already married elsewhere and settled in her life. She appearing before this court may create may cause a disturbance in the in her family life. Therefore, she is not willing to participate in the proceeding. However, through her counsel, she submits that she stands by the affidavit and settlement term. Affidavit filed before the court below and the settlement terms. On the counsel for the opposite party number 2 in these circumstances makes an oral prayer for exemption from exemption of the opposite party number 2 from appearance before this court for the reasons for the aforementioned reason. The exemption of personal appearance of the opposite party number 2 is exempted for the purpose of the present proceeding. Mr. Pratap, learned counsel for the state, submits that if the dispute is essentially arising out of a matrimonial discord and the parties have settled their dispute, marriage between the petitioner and opposite party number 2 has already been dissolved by a court of competent jurisdiction. Therefore, there is no legal impediment in quashing the FIR regarding head to the aforementioned facts and circumstances of the case and relying upon the judgment of so. Yes, quashed.
But report that
despite none appears for opposite. Mishra appears for petitioner, Mr. Vishwa for the state, none appears for opposite party number 2. In the interest of justice, by way of last opportunity, the matter is adjourned to such and such state. It is made clear that if the opposite party number 2 will not appear in the next date of hearing, the matter will be proceeded in his absence. Leaves the matter in such a interim or to continue. Yes. 3 4 weeks. Yes. Yes.
60.
Your Lordship, under the petitioners on behalf of Mr. S.K. Das, we have filed this application for challenging the order dated 18/9/2024, passed by the Learned JMFC Cutter, including I-1 CC case number, two separate cases, 86 and 87 of 2023. Your Lordship, we have actually come challenging the 143A in Act order, wherein interim 20% of interim compensation has been asked.
What is the check amount?
The check amount was 1.2 and 1.3 crores. So 20% would be roughly coming to approximately 20 lakhs and 26 lakhs. So your Lordship, actually we are playing that if the matter could be sent for mediation, because there's a
at least 10%, Lordship. I have order of the Lordship where it's subject to payment of 10% at least.
In that situation, we are ready to pay 10% and
I'll send you to mediation.
Yes,
No. See, listen one thing. You pay 10%. I'll set aside the order. I will send you to the trial court to move another application for waiver for that condition. Meanwhile, the trial court will send it to mediation and do it.
What I'm saying is that 2 cases, two cases, the amount will come to 2.5 crores. Now, what I am saying is if the lordship send this matter to subject to payment of 10% and lordship send this matter to the mediation country in the High Court, there is a chance of the matter being settled. Therefore, without crossing the order and ending matter the lordship may give us at least one week.
Yeah, that we are fine by that, but one clear your lordship in just because we are agreeing to pay 10%, if your lordship allows us some time to arrange the money.
How much?
2 months, your lordship.
No, 2 months.
At max 30
If
days.
you need say long time, then you go to trial court. I'll make that that concession I will give you, but deposit that money and let it be negotiated with it.
Last date is 19th of this.
No, I'll give time. Go to trial court. That's a better idea. Right on. Petitioner is agreed by the order dated 18/9/2024. What is that order?
Page number 30, operative portion and page number 30.
30?
3013.
Yes.
Last paragraph.
Agreed by the order dated also passed by JMFC 2 Kotak. Whereby the petitioner is directed to deposit 20% of the check amount, which comes to
20 lakhs.
20 lakhs 50,000. 20, 50, 041.6.
Yes, your lordship.
0.6. 0.6 being the under section 143 capital A of NI Act. The petitioner is agreed by the state order and has filed the petition. Learned counsel for the petitioner submits that due to the financial stress, he is not able to arrange the said amount, hence seeks leniency. At the outset, the counsel for the petitioner submits that his clients are ready and willing to settle the dispute through mediation. Mediation subject to the condition that the petitioner shall make good payment of at least 10% to begin with. To demonstrate bona fide on their part, in their part. The counsel for the petitioner is also agreeable to the same terms. Regarding head to the aforementioned, I am of the consent review that the petitioner shall deposit 10% of the check amount within 8 weeks. Let him do within 8 weeks. Within 8 weeks, and liberty is granted to the petitioner to move separate application before the trial court for variation of the order, variation of the impine order, which the remaining 10% is concerned. Remaining 10%. The trial court is also directed to refer the matter to the mediation center, district mediation center, to explore the possibility of a out of court settlement. With this observation, the petitioner is disposed.
Settlement of the entire amount.
It was settlement of the entire dispute. Entire dispute.
That's over there.
Yes, entire dispute.
Yes.
Entire dispute.
Your lordship.
With this observation, petitioner.
So it is 61 is a similar matter, your lordship, on the same.
61 is the same thing.
Yeah. The amount of
Will do. Don't worry. But you paid 10%, then you show your bona fide, then only the question of negotiation.
Yes, certainly.
Yes.
62.
Yes.
We are applying even if it is a party, but copy is not sought.
I have already sent through notice and also served a copy to the United of India. I have also the receipt with me. Directed to send it to registry post and I will send it to registry post.
Service complete.
Yes.
And you are appealing for Union of India. He is entering with the so and so on behalf of Union of India and seeks an adjournment for seeks recommendation, seeks time to file response to the petition. However, he submits that he has not received the copy of the petition. Let the counsel for the petition supply the copy, release the matter. Yes.
Press copy maybe, sir.
Yes.
My name will be.
The matter which I have engaged that matter regarding this police officers and army. Why not directed to be distributed in the due course? That's all right. There are two other matters. One matter was there before my lord, this is we are saying. And another matter was there pertaining to the same thing today. So on the before directed that since your lordship is hearing both the matters, maybe listed. One of them is urgent because the armed forces.
But unless it is routed through Chief Justice, I can't do anything.
My lord, it has to come to my lord.
But Chief Justice has to endorse it. I can't pass a preemptory order.
All right.
Let it go to the Chief Justice, then I will be mentioning thereafter. Formally, it has to go to Honorable Chief Justice. I can't. Yes, I can't. That's the better idea. So that it will be listed anytime.
Because one urgency is the telephone has been seized and they have sent it for forensic, not realizing this is armed forces officers telephone.
Better go to Honorable Chief Justice and mention while writing.
All right.
So that I can't help it.
On the reopening, no, I'll have
Yes.
reopening for the next day.
Yes. Yes.
I'm so sorry.
That's all right. Yes.
62 next week.
Yes. We'll give it.
Obviously.
Yes, sir. Yes.
At the outset, before going to the case in hand, my friend Sangram Babu is here on behalf of the Vigilance Department. I want to place the matter so far the addition of a spouse with the add of section 109 of the Indian Penal Code. And I have gone through the decision of our own, I have my own decision also. But I want that the laws would be clarified, keeping in mind 107 and 108 of the Indian Penal Code. So it will take time. If your lordship give me the time, I will ready. Otherwise, or someday I will hear it. Because what happened, my lord, ମୁଁ କହିଦେଉଛି ଖୋଲିକିରି ମୁଁ ଯେତେବେଳେ ଇନିସିଆଲ ପ୍ରାକ୍ଟିସ କରିକି 30 ବର୍ଷ ପ୍ରାକ୍ଟିସ ହେଲା 109 ରେ ଇଏ କେସରେ କରୁଥିଲି ଏବେ ଇନଭେରିଏଣ୍ଟଲି ସବୁ କେସରେ କରିଦଉଛନ୍ତି କରିବା ଠିକ ଅଛି ଯୋଉଠି ଅଛି ଇନଭେଷ୍ଟିଗେସନ ମଷ୍ଟ disclose that the other spouse abated the commission of guilt in the absence of that material because some of the properties are in the name of the other spouse he cannot be arraigned as accused with the act of section 9 that is the crux of the matter.
107 you're talking.
Abatement of the thing and abator, the two definitions must be reflected in the during course of investigation and material must be placed before the court. So court will act upon that colleague of another person with the act of section 109. That is the cross entire cross.
I'll list it up. I'll just adjust. Application. No application. We'll adjust and give it. Yes.
64.
I'm agreeing on behalf of the matter. We have not a copy of it.
Copy of the appeal has been sought since long. It is 2008 matter.
2008 matter.
Yes. And it was hard also.
One time that's a different story, but not in this pretext. Not in this pretext.
Several times before different.
What is this matter?
Again, the conviction of 1 year and 50,000 fines. And the appellant is no more. He died in the meantime. His wife is also dead. The children are pursuing this application.
394 application is already moved.
Yes.
It is allowed. Okay.
In this case, you are the credit manager of the DIC. He has forwarded the decision of the committee for grant of the loan amount. A loan in Government of India has launched a scheme, that is self-employment of educated youth. Self-employment for educated unemployment scheme. Under the said scheme, 25,000 was being paid to the person in which favor the loan was granted. The loan amount was sanctioned as per the decision taken by the DIC. And he was the appellant was the credit manager. But when the decision was taken, he was not the credit manager, because he was the credit manager or the convener of his meeting.
Yes.
But he was not the credit manager at that point of time when decision was taken. Thereafter, he joined after 4 to 5 months after. And at that point of time, he only forwarded the decision to the judge. And because of that, he was faced the trial. He faced the trial, and so far as the others are concerned, all have been discharged.
Discharge. You have been convicted under 13(2) and 13(1)(d).
Yes.
D.
1 year and 650,000.
For 420 also.
Yes. 420, yes, 420 also.
You are convicted for 420, 13(2) and 13(1)(d).
So I made a written note,
Mm.
written note, and another also a list of debts. Both are on the, I think it is on the top.
You got those papers? No.
No, your lordship.
You go to Madam's chamber and get those papers. I'll return it in the list itself. Let it
Lordship,
be
I clear
ready.
to settle matter after 4 weeks.
No, 4 weeks. 2008 matter. He ready.
So appear once.
Let it be.
Yes, I will.
Let it be in the list. Get the copy and get ready. Yes.
Next week.
It will remain in the board. Remain in the board. Yes. All matters remain in the board.
Next week it may be.
I will not disturb the board. Board will remain like that.
Lordship, weekly matter item 140. Lordship, may kindly next week.
I'll take it up. I am not disturbing the board. The board will remain like that only.
Your Lordship, weekly matter 119. In that case, Your Lordship, the FIR was filed 12 years ago. Until date, no final form has been submitted. And the petitioner has been victimized in that paper.
Where item 400?
119, Your Lordship.
119. Weekly the you come against which order? You come against which order?
Against, we have come challenging the FIR, just watch the FIR, Your Lordship. And on the last 2 occasions, Your Lordship, on 7th of October, as well as on 29th of October, Your Lordship had directed the Learned State Council to file a response regarding the delay in the investigation. Till date, no response has been filed.
It's 119. Huh? These criminal miscellaneous matters are also obligated.
Because actually in the Monday list could not be completed, so it is still there.
But this is that. Lordship say.
No, don't put in here weekly. Against permission.
Last time it was from item 53 to 133 to be taken on that day. That was the market. So it could not be taken, so it was there.
But you have to bring them to supplementary one after another. Otherwise, it will never come.
That one.
Lordship,
I wish my Lord safe journey.
You have to get instruction. I am in this matter. I'll put it in the supplementary list. I will take it up.
Lordship, I beg to pardon, my item 140 weekly list also may kindly in supplementary.
I'll take it up.
Lordship, I beg to very
a small matter. Petitioner is a juvenile at the time of occurrence. Can it be taken up on supplementary list of?
It is vigilance or? No, it's a juvenile use, obviously not vigilance.
It is 6 month conviction. Petitioner is a juvenile by the time of occurrence. He is a meritorious student.
इसको देखो हो सकता है you will let it. Who will adjust? You will adjust. He will adjust. Thank you very much.